the thing about this stuff on your cell phone is you can't erase it. I mean, I've had clients do it. They will buy the software to download it to delete the data on your phone. I've had clients use 2 different applications to try to scrub their phone. And all that happens is, number one, when law enforcement examines your phone, they can see that you downloaded a scrubbing device, and they can still go back and find everything. So you look even more guilty because you now look like you're trying to cover things up. What's good, people? I'm attorney John Mobley. I have prosecuted and litigated complex civil and criminal cases for over 30 years, and I'm still actively litigating these cases today. My experience was forged in the legal trenches, going toe-to-toe with some of the best lawyers in the country, and I'm still actively litigating these cases. On this podcast, I'll be giving no-holds-barred, hard-hitting legal analysis on the legal issues that are gripping the nation. But you want to hear more than just legalese or legal mumbo-jumbo. It's important to have the perspective of a non-lawyer. So my assistant Kayla is joining me in the podcast, and she's going to ask me the tough questions for which you want the answers. So please join me on Legal Deep Dives and listen to me call it like I see it. What's good, people? Attorney John Mobley here. Welcome to Legal Deep Dives here in the club room with Kayla and the production team. Guys, you guys look as good as you want to look. Kayla is always looking like $1,000,000. We're here today to answer all the questions you have about the hottest cases that are gripping the nation and that has everyone's attention. Before we start, do me a favor, go ahead and like and subscribe so you get all the latest updates, get to see me, and get to see Kayla. How you doing today, Kayla?
Good. How are you?
I don't think anybody cares, Kayla. I think they want you to get right into it. What do you want to know? What do they want to know? Ask me the tough questions about today's cases. What case are we talking about?
We're going to talk about Mackenzie Shirilla.
Ah, yeah. Psycho Girl.
Yes, the car crash from hell.
The car crash by the train wreck.
Yes. So, what is a summary of the case? How can we get into the investigation that led to her arrest?
Well, something I see all the time, Kayla, in criminal cases are individuals that commit crimes. They fail to adequately take into account the digital footprint they leave behind with their cell phone, their devices, their PCs, their vehicles. This age where, cities and towns have cameras on the street corners, businesses and homes have, video cameras that record things. And typically, so many defendants fail to take that into account, and failure to do so leads to their arrest. In this case, this defendant, Mackenzie's cell phone, and of course, everyone knows there's a crash where, the basic underlying facts are, she allegedly intentionally crashed her car in order to cause the death of her boyfriend and friend, and tried to make it look like it was an accident. Mm-hmm. But by obtaining her cell phone during the investigation, they're able to determine that she'd actually been to that location on prior occasions, basically trying to case it and kind of scope it out to make sure that her plan was going to succeed. They're able to find that. They're able to find text messages that, where she's making statements to her boyfriend that sound just borderline crazy, threatening to do violence to him, threatening to do serious physical harm to herself. I mean, she was unhinged. And the thing about this stuff on your cell phone is you can't erase it. I mean, I've had clients do it. They will buy the software to download it to delete the data on your phone. I've had clients use 2 different applications to try to scrub their phone. And all that happens is, number one, when law enforcement examines your phone, they can see that you downloaded a scrubbing device, and they can still go back and find everything. So you look even more guilty because you now look like you're trying to cover things up,
right?
Which you are. You're trying to hide stuff. So that led to her downfall. And the text messages. People will forget if you're making threats of violence and things like that. And you're a witness to a violent crime. They're going to look at your phone. They're going to get a search warrant if you're a suspect. They're going to examine your phone. And thgoing to find all that stuff.
And they don't care if it's a joke. If you're just messing with somebody, it doesn't matter. They're not going to know that. They're going to see a text saying, I'm going to kill myself. And they're going to take that seriously because of something that they said.
They're going to see a pattern. Mm-hmm. And from there, they will determine whether or not they believe it's a joke or serious by trying to corroborate that with the investigation. They would interview witnesses to find out, okay, well, we've seen text messages that this person was making statements like this. What's your opinion? Oh, they were just joking. They joke like that sometimes. Or no, she was unhinged. They were crazy. It was a toxic relationship.
It was constant. Yeah, always fighting.
And it was corroborated by the witnesses. So that's a problem. And in her case, most cars today have what are, commonly called CDRs, which means or stands for crash data recorder, or EDR, event data recorder. Sometimes there's something in the airbag module, but these devices are the equivalent of the black boxes that people hear about when airplanes crash. And how when the airplane crashes, you hear them saying they got to get the black box, which records everything going on the plane at the time. Same thing with vehicles. It'll tell you, and the way these devices work, they have to be downloaded, but they don't record constantly. They typically only start recording when there's some significant event going on with the vehicle. Mm-hmm. A good example is a tire blows out, it hits an object, or the driver starts, steering very aggressively, it jams on the brakes. It starts recording what's going on with the car.
Or puts the gas pedal all the way to the floor. Exactly.
So it'll record the speed, if there's increases or decreases in the speed, whether or not somebody jammed on the brakes to try to avoid the collision, whether someone, grabbed the steering wheel to try to, or turn the steering wheel to take, action to avoid the collision. A number of things like that, whether the lights are working, whether the tail lights are working, all that kind of stuff, whether the tire blew out, to try to determine what caused the crash, or what contributed to the crash. And in this case, when they downloaded the crash data recorder, they were able to determine that not only was she traveling at a high rate of speed, but there were no attempts from a braking standpoint to slow down. And from what I understand, the crash data recorder also indicated that the steering wheel was being turned back and forth, which they believe, and I think is consistent, with someone in the car trying to grab the steering wheel and take control of the car to prevent the crash.
Yeah, because I was also informed that there was a note that the car was in drive and then went to neutral and then back to drive. So someone must have attempted to try and stop it.
That's right. That means somebody's trying to stop that collision from taking place. There's a struggle. All those things were inconsistent with her version of this being an accident. And the problem is for the defendant and the defendant attorney is, once that digital evidence is out there, now the defense attorney's got to deal with it. One of a couple different ways. First thing, you got to hire your own experts. And, you look to argue, okay, well, maybe we can argue that the manner in which information was collected was unreliable. So we can't assume that, their conclusions are correct about, what they are. Well, typically that's just very, very difficult. As a matter of fact, I routinely, in accident cases and in civil cases with car accidents, I will routinely have experts download the event data recorders in the vehicle, and oftentimes me and the defense lawyer will just agree we'll have the same person do it. Because there's typically no way to kind of alter or misread or screw that up. The data is what it is. Okay, they just stick in something and download it.
Yeah.
So you can't really alter that or extract that in a way that's unreliable. We will agree on the same expert to save money. Instead of paying some guy $5,000, we'll pay one guy $2,500 each. And so if you can't attack the reliability of the process by which the data was collected, now you have to try to argue perhaps, or find some way to argue that the results or conclusions are not necessarily consistent with a crime, but there's a reasonable explanation for that information. For example, the law enforcement theory that because her phone, had her at that prior location on multiple occasions prior to the accident. Well, what you're going to want to do is talk to your client and see if she can give you a reasonable justification for why she was there.
Right.
Maybe there's a library there. Maybe there's a coffee shop there that she likes. Maybe if you check that phone data back 6 weeks, 8 weeks, 2 months ago, you'll find her going to that same spot over and over, not just in the days prior to the murder or the crash. So, but again, if your client doesn't give you anything, you're kind of stuck with that. Mm-hmm. So that is a problem when you have all that digital evidence, rather, is that the defense kind of has to deal with that as opposed to a witness that you can try to argue is perhaps doesn't have a reliable memory, or maybe has some bias, or is given an inconsistent statement. And I will tell you that based on my experience, the more that digital evidence that they have, the tougher it is to overcome. Mm-hmm. I mean, you can always, if there's just one thing, you can always make an argument that they can't base their entire case on the assumptions, of how they interpreted that evidence. For example, if it was just the car and the steering, you can say, okay, well, maybe they're both trying to mutually avoid the crash, and they're both freaking out because they were young, not necessarily somebody struggling to battle over the steering wheel. You could kind of make that argument, and that argument would kind of make sense. But when you have multiple, devices, the phone, the car, the cameras, all consistently kind of suggesting the same thing, it's a very, very uphill battle because the numbers just kind of catch up with you.
All right. And then kind of going back to that, she was saying that it was her POTS that caused it. She was dizzy and she was fainting, like she passed out, but the accelerator was at 100. Can you talk about the process when somebody says it was a medical condition in a car accident, or kind of how that process would work if it really was her POTS? Like if it really was a medical condition, how do they go about changing that direction? Well,
I think the problem, as I indicated a minute ago, is that if there was just that one thing, okay, yeah, you can maybe try to argue that. The problem is when you start looking at the text messages, she's talking about crashing cars. She's talking about causing harm to herself, talking about, causing harm to her boyfriend. I mean, she literally talked about, or either made statements or had texts about crashing the car like days before it happened. So again, the problem is that that theory of law enforcement and the prosecution is corroborated by the cell phone. So their conclusions about the vehicle and about the nature of the crash and the circumstance of the crash are corroborated by a completely separate device. And that becomes a problem. But with regard to her statement that she may have had or she had POTS, and just to make sure everyone understands, POTS is similar to vertigo, that dizziness you get if you stand up or move too fast or at imbalance. Apparently she alleges that her POTS condition contributed to the accident as opposed to it being intentional. Well, if you're the defense, and I'm going to explore that, well, obviously I want to make sure that she has it, okay? Which means I'm going to, talk to the medical professionals to see if she's been treated for it, to make sure I can confirm from a medical standpoint, I've got a medical professional that will say, yes, we've treated this girl. She does have this condition, and these are the symptoms, okay? From there, the question I'd want to explore is, okay, well, should she be driving? Is she taking medication for it? Is this something that she's receiving treatment for? Because she has that condition and she's receiving treatment for it and she's taking medicine for it, that makes it a lot more believable, a lot more reasonable to say that's what happened. There's no doubt about that. But I think you kind of still have to balance that with her statements in the text messages. And that's a problem. That's in a vacuum. If you just have that one thing, if all you have is the accident and you don't have the other digital footprint that she's leaving, that's a perfect example of what I'm saying. You have a great argument that it was an accident. They can't prove it was intentional. She has a medical condition. The doctor's not lying. It's documented. Horrible things happen. And yeah, you can kind of sell that story. But with everything else, with the text messages, with the statements, with the behavior, the threats of violence, of physical harm, I think that those things would kind of overtake the whole idea that this was called because of her medical condition.
And so she was convicted of murder, vehicular homicide. And then she got two, what's the word?
Concurrent life sentences.
Concurrent life sentences. But then she got, the probability of parole. How does that work? How are you going to say that she's going to have 2 life sentences and be like, well, maybe we'll just kind of let you, back into your house and that's it?
Okay, let's talk about that. First, a lot to unpack there. When a person is convicted of multiple crimes and the judge gives a sentence, he can make the sentence one or two different ways. He or she, rather, can make the sentence one or two different ways. It can be consecutive or concurrent.
Okay.
Now, what you don't want if you're a defendant are consecutive sentences, because what that means is you serve the time for each offense separately, which means if you have two 25-year sentences, you serve the first one, the first 25 years, and then when that one's over, then you start serving the second 25 years. So if you're a defendant, that sucks, okay? You want concurrent time, which means that all the sentences run together. So you're serving, if you have 5 25-year sentences and a 10-year sentence and a 15-year sentence, then you're not serving any additional time for all the other charges, okay? So her sentences were made concurrent, which means they run together. That's what she wants. I mean, trust me. Now, with regard to life, that's just been a common complaint by victim advocates around the country when it comes to life sentences. I mean, most victims complain about that, and they want truth in sentencing because every state has different guidelines for parole eligibility. Okay, for example, in South Carolina, in some cases, a person can get a 10 or 15-year sentence, but because of the way the crime is classified, they only serve a quarter of that sentence, and they can be released on parole, which means if you got a 10-year sentence and it's 1/4 parole eligibility, that means you serve 2.5 years and you can get out. So 10 years is not 10 years. Or 10 years on another crime might have a 1/3 parole eligibility, which means you serve a third. And of course, there's there's also something here called 2/3, which means it's non-parolable because you have to serve so many days before you can be released. 2/3 is 66%, and there's certain charges that are 85%. So, and really, sometimes even criminal defense lawyers get confused because a client will say, okay, well, how much time am I going to serve? You kind of got to research all that to make sure you're looking at the right classification.
Yeah.
Or in some cases, you can use that as a negotiating tool where, okay, well, I'll take the 10 years, but hey, reduce it to a Class E felony as opposed to a Class F. So now my client's only got to serve 10 years instead of 8. Okay. Now, with regard to life, it's the same thing. Life does not always mean life. Life is a term of art that legislators use. And in some states, like we're in South Carolina, right now in South Carolina, life means life. If you get a life sentence for murder or anything else, life is day for day. There's no chance of parole. You will go to prison and you will leave in a box. Okay? You will die in prison. But 30 years ago in South Carolina, life meant you got paroled in 20 years. Okay? Now, in the state of Ohio, their murder statutes are similar. They'll say life, but typically, a person can be paroled after 15 or 20 years. And in her case, the judge did make her eligible for parole in 15 years. So although she got 2 life sentences, number one, they're concurrent, which means she's only got to serve the one for all intents and purposes. And 2, yes, it is not day for day. There's no truth in sentencing. She will be eligible for parole in 15 years. So depending on, how she acts in prison and things like that, she could very well be out in 15 years and still be, in her early 30s and get a brand new lease on life. Yeah.
And let's talk about bench trial. Why would it go that route instead of jury? Do you think that was the right decision in this case?
Okay, yes. And to make sure everyone understands, the defendant in this case, Mackenzie, her and her attorneys requested a bench trial instead of a jury trial, which I agree. Most people think it's odd because most people want their case tried by a jury. I want to jury my peers. I want a jury trial. And I will tell you that in general, I mean, 99% of the times you want a jury trial because with a jury trial, in order to be convicted, it's got to be a unanimous, simultaneous agreement by the jury, the entire jury panel, that you are in fact guilty, which means that they all 12. If 11 people think you're as guilty as sin and one person just says, you know something, I just don't think they did it. I don't think we heard all the evidence. I'm not going to convict them. Then guess what? It's a mistrial. You can't be convicted. So, you always, want to think you have one or two people you can kind of convince, to accept your theory of the defense that'll find on your behalf. And that's why most people want a jury trial. Now, the case that I've seen where people want a bench trial is typically when the defendant has a very, very bad facts, and the defense may be a technical legal defense, or perhaps some element of the crime is not met, and they're concerned that if they take the case in front of a jury won't really see that fine distinction. The jury may see, for example, here the evidence about her text message, about her behavior, and just assume she's guilty.
Yeah.
As opposed to rather making a decision based on the evidence or lack thereof. That's very, very risky. And also I want to make it clear that, particularly in South Carolina, that even if a defendant wants a bench trial, the defendant's not the only party that's entitled to a jury trial. The state is also entitled to a jury trial. Well, I've defended cases where I kind of would have wanted a bench trial, and I had the state said, no, we want a jury trial, and we had to have the case tried by a jury. So in this case, the fact that they wanted a bench trial leads me to believe they felt like the intangibles in the case, her behavior, her character would probably rub a jury the wrong way, and they would convict her based on that. And they had a better chance of a judge finding reasonable doubt existed as a matter of law. But obviously that didn't work out in their favor.
No, it did not. And
I think, and the problem with that too is there's a downside to that, because when you have a jury trial, the jury's ruling on, there's evidence that's being admitted. You're objecting to it. You're objecting to jury charge. You're objecting to the admission of evidence. You're objecting to statements and testimony. And if you lose those objections and your client's convicted, those are issues on appeal. That the judge should not have let this testimony in. The judge should have kept that evidence out. But when it's a bench trial, judges aren't swayed by evidence that's so prejudicial. Judges are typically more objective, and and I believe your chance on appeal is substantially lower when you have a bench trial as opposed to a jury trial.
Well, the Ohio State Supreme Court did deny to hear her appeal, and retrials have been unsuccessful for her attempt to get one. What is the limit on getting denied for an appeal? Like, is there certain things, like, is the bar set low or is it high to get a denial for an appeal? Well,
when you appeal a conviction in a criminal case, typically, it's a process. Depending on it can be, the appeals in this case will probably take a good decade.
Yeah.
Okay, because first you have your state level appeal based on errors in the admission of evidence, or based on how the case was tried, based on rulings the trial judge made or decisions the trial judge made. And that's your typical first level of appellate process you go through, and you do that in state court. And you have to go through that process first. And typically most states have a lower appellate court and a higher appellate court, and it really kind of depends on where you start. But that highest appellate court, even if you lose at the first layer, you can still appeal to that higher court, and that's kind of where the line ends when it comes to those type of appeals. Now, if you lose all those appeals, okay, you have two additional avenues. All right, the first one is called post-conviction relief. Okay, and you do that in state court. And one of the most common grounds of post-conviction relief is ineffective assistance of counsel. That although there were no errors of law committed by the trial judge, the trial attorney made mistakes perhaps in how they prepared, perhaps in their strategy, perhaps in ignoring witnesses and evidence that was available to them, that you provided them with and they didn't use it, perhaps in how they advised you regarding the trial. And that's something very common. And I've had it done for cases that I've lost. I mean, and I don't take it personal. I mean, you got defendants sitting there in prison. They're serving 25, 30 years. They're going to exhaust all their regular appeals and they go, okay, what can I do next? Okay, well, let's try to get me a new trial based on ineffective assistance of counsel. And I've actually had cases where former clients just lied and say I did all these things or I didn't do all these things. They told me these things, and it's just like, fortunately, I document my file. But they're desperate. So that's going to be the next level for her, ineffective assistance. And from there, if she loses at the state level, the next phase is to apply in federal court for something called habeas corpus relief. Yes, I'm using legalese. Habeas corpus, that means produce that body. But what you're arguing in federal court is that their federal constitutional rights are violated. And I want to just make sure I explain that. Every state has their own independent constitution, okay, which is separate and distinct from the federal constitution. So a defendant in a criminal case is guaranteed and entitled to protection from not only the state constitution, but also the federal constitution, okay? However, the state court does not have jurisdiction over federal issues, okay? So once you've completed the process of alleging constitutional violations, ineffective assistance of counsel in state court, you still have the opportunity to try to pursue that in federal court, okay? Now, the federal court doesn't have to necessarily agree to hear it, but that'd be the next step. But ultimately, what a defendant does is they will exhaust every single appellate remedy they have, which is why these appeals just will take a decade.
All right, so tell me a little bit about how social media had an effect on the trial and to what extent can content be used in a trial? Because sometimes you see stuff and people make theories about it, but it can't actually be used in there. And sometimes there is stuff that you can use against them. So tell me what was used and what's the extent?
Well, it kind of goes back to my statements about the digital footprint that you leave behind. Because oftentimes, what a defendant puts on social media is either inconsistent with or consistent with different aspects of the case. Particularly, if you're claiming that you're and I've had it happen in cases where I've defended people where we use it to their advantage, where you have someone claiming to be a victim, perhaps of a sexual assault or a victim of some other horrific crime, and they claim to be traumatized, and they're talking to the police, and they're crying, and they're just devastated. Yet you look on their social media, and the next day or 2 days later, they're up in the club, posting pictures of themselves in a bikini, having drinks, living their best lives. That's inconsistent with someone that was sexually assaulted or the victim of a violent crime 2 days earlier, or someone that's suffering from severe trauma where, hey, when they spoke to the law enforcement investigators, they just breaking down and sobbing uncontrollably because this is so horrible, yet you leave and 20 minutes later you're doing shots.
Yeah, I never want to see another man again.
Exactly. So, and again, that conduct is inconsistent with someone being a victim. Also, again, if you're making statements, threats, or other posts that are consistent with your intent to do harm to someone, that can be used, okay? Because people do that. I mean, people will get on social media and they will make them publicly. They will make private, threats to individuals. That's all there. So again, if you're trying to claim that something that happened was an accident, yet you have a history of making posts on social media of threats, of violence, and similar conduct, that actually shows your intent in order to overcome the accident. And at sentencing, if a person is convicted and they're sentencing, the reality of a defendant being sentenced is Every defendant. There's a phrase as one judge, used to say, every defendant, no matter how hollow of a crime they committed, no matter how bad their record is, every defendant shows up to court, shaved, saved, and sorry. Mm-hmm. And are just expressing so much remorse for what they did, and they've learned their lesson, and this is out of character for them, and they are truly sorry. But again, if your conduct after the crime on social media shows that you're out there living your best life, you're doing shots, you're at the club, you're at the party, you're sticking your butt out for the cameras, the guys can do that too, not just girls. You're in your bathing suit, you're doing shots, you're just saying vulgar things. That is not consistent with someone that is remorseful for their conduct. Mm-hmm. And that type of conduct, that type of content, when it's being shown to a judge after a person has stood up and just said, I'm so sorry, Your Honor. This is a horrible, horrible tragedy. And, I've been struggling with it. It's been traumatizing for me. And I'm so remorseful. And then you see those videos and those posts and those pictures and those comments. That's something that's going to show a judge that you are not remorseful, mm-hmm. that you're actually somewhat callous about what you did. And that's what happened in this particular case. The judge is made aware of that evidence, that content, and was not inclined to believe that this defendant was remorseful. And what that means for the defendant is, instead of getting less time, you get more time, years in your life.
Yeah. Well, I think that's all I have on my end. Are there any final thoughts or anything we didn't talk about that you just want to get off your chest? And lastly, do you think it was intentional? Or do you think, this was an accident?
I got to call it like I see it, Kayla. This young lady had severe mental health issues. Her behavior was just documented by her friends, the witnesses, the people in her life. The signs are all there.
No, that was just her POTS.
And it seems like, her parents just ignored it. And she didn't get the help that she needed. And I see this all the time. I had a deposition myself this week where it's a wrongful death lawsuit where I filed a lawsuit where this 13-year-old kid stabbed a 19-year-old kid to death. And
16.
I'm suing the defendant's family for negligence. Now he was supervised. And this 13-year-old kid, his history of behavioral issues, start from kindergarten up until the time, just constant. And I'm taking his mother's deposition, and and her position in the beginning is just her son didn't do anything wrong, and he that's not how it happened. He killed that teenager in self-defense, and there's more to the story. And I asked her if she was aware of his school history, and she's like, oh, he's blackballed. And I'm just asking her, and I'm going over like years of incidents of violence of her son at school. Of assaulting students, males, females, bringing weapons to school, making threats to teachers, just 2 and 3 times a month, it's in the school records. And she's admitted she's had to go up there and pick him up from school, and he's been suspended again. He got sent to the alternative school. He got kicked out of the alternative school, They sent him for a mental health assessment. She refused to give him the medicine. And there are parents that are just like that. They just don't believe their children can do any wrong. Mm-hmm. And I truly believe had this young lady received appropriate mental health treatment, this probably would not have happened. Well, that's going to be it for today. Those are my opinions. You might agree with me. You might think I'm a crackpot. I really don't give a damn. Either way, do me a favor, post your comments, call it like you see it. That's it.